My name is Diane Whitfield. I'm 47 years old, and for the last 19 years I've worked as a trust and estates attorney in Charlotte, North Carolina, the kind of lawyer families call when money and blood start pulling in opposite directions. My ex-husband Richard didn't know that when he stood at our son's basketball game on October 11th, 24, wrapped his arm around his new wife, and announced to the entire third row of bleachers, "Some men just know how to pick a winner. Vanessa's about to come into some real money, and I'm about to retire at 52. He said it loud enough for me to hear. He always did things loud enough for me to hear. I smiled, clapped for a three-pointer that wasn't even ours, and said nothing. Richard had spent our 14-year marriage measuring his worth against other men's bank accounts, and now he was measuring it against an inheritance that belonged to a woman he'd known for exactly 2 years. What he didn't know, what neither of them knew, was that I had spent the last 8 months as outside counsel to the trust that inheritance was sitting inside of. I knew the account balances. I knew the beneficiaries. I knew things about that money that Richard Calloway would have needed a subpoena to find out. I just hadn't told him it was me. By the time this story ends, Richard's new wife will have lost access to a fortune worth just under $4 million. A woman named Margaret Ellis will still be alive to see her real family protected, and Richard will have said his little catchphrase, "Some men just know how to pick a winner," for the last time in a room where I was the one holding all the paperwork. There's a moment near the end where Richard finally understands what I do for a living, and I want you to see his face when it happens. Not because I enjoyed it. Because I'd spent 3 years being told my job was cute and safe and not exactly ambitious. And it turned out to be the only thing standing between an 81-year-old woman and losing everything she'd built. If you've ever been underestimated by someone who used to know you, stay for this one. Before we get there, hit subscribe and drop a comment with your city and what time it is where you are right now. I read every single one, and I want to know who's watching this with me. Because what happened over the next 11 months involved a hospital bed, a signed document nobody was supposed to see, and a phone call I made from my own driveway at 11:40 p.m. That changed 4 people's lives. Comment your city and time, hit that subscribe button, and let's get into it. Let me take you back to where all of this actually started. Not with Richard, but with a woman named Margaret Ellis and a career I built long before I knew her name would matter. I grew up in Gastonia, 20 minutes outside Charlotte, the daughter of a machinist and a school cafeteria worker. My parents didn't have money, but they had a specific kind of respect for people who did, not envy, just a quiet understanding that money, once it existed in a family, needed careful handling or it would tear that family apart. My father used to say, "More people lose family over an inheritance than over anything else in this world, Diane. More than religion. More than politics." I didn't understand him until I was 26 years old and watching my own law school classmates fight over a professor's estate in a moot court exercise designed to teach us exactly that lesson. I went to UNC Charlotte for undergrad, then Wake Forest for law school, graduating in 2001 with a focus that most of my classmates thought was boring. Everyone wanted litigation. Everyone wanted to be the person yelling objection in a courtroom. I wanted trusts and estates, the quiet work, the paperwork that decided who got what after someone died, the fiduciary duties that most people never think about until they desperately need someone who understands them. I passed the bar in 2002, took a position at a mid-sized firm called Presley and Odom, and spent the next decade learning the difference between a revocable trust and an irrevocable one, learning how undue influence gets proven in court, learning how elder financial abuse actually happens, slowly, quietly, through small signatures nobody questions until it's too late. I met Richard Calloway in 2007 at a mutual friend's wedding in Asheville. He was 33 then, a sales director for a regional building supply company. Charming in the specific way that salespeople are charming, attentive when he wanted something, distracted the moment he had it. I want to be honest about this part because I think it matters for understanding what came later. Richard was not a villain from day one. He was a man who liked being envied more than he liked being loved, and for the first several years of our marriage, I didn't see the difference. We married in October 2008. Our son Tyler was born in June 2011. The early warning signs were there, if I'd known to look for them. Richard introduced me to his coworkers as my wife. She does paperwork for rich people's wills, a description that was technically true and completely wrong, the way a lot of Richard's descriptions were. when I made partner at Presley and Odom in 2015. A milestone that took me 13 years of billable hours and continuing education and 2 additional certifications in elder law. Richard's response was, "That's great, babe. Does that mean more money for us or just more hours for you?" I laughed it off. I told myself he was joking. My father's voice would occasionally surface in my head. More people lose family over an inheritance than over anything else, but I never once imagined it would apply to my own marriage. The real fracture started around 2018, when Richard's building supply company was acquired and he was let go in a restructuring. At age 44, with a severance package that lasted 7 months and an ego that couldn't survive the unemployment. I was, by then, earning close to $210,000 a year as a senior partner handling estate litigation and trust administration for high-net-worth clients across the Charlotte metro area. Richard never said it directly, but I watched something shift in him during those 7 months, a resentment that didn't have anywhere else to go, so it went into our marriage. He started making comments about my hours, about how convenient it must be to bill $400 an hour, just talking to old people about their money, about how he used to be the provider, and now he was basically staff. I want to be precise here, because precision matters in my line of work and it matters in this story too. Richard was never violent. He was never cruel in a way you could point to in a courtroom. What he was corrosive, the kind of husband who could make you feel small in a sentence that, read on paper, sounded almost reasonable. I just think it's interesting that you have time to go to Pilates but not time to help Tyler with his math homework. I just think it's interesting that your paralegal makes more in overtime than I made at my old job. Small sentences. Constant ones. We separated in January 2021, after Tyler turned 10, following an argument that started over a $340 grocery bill and ended with Richard saying, "You know what your problem is, Diane? You think because you handle other people's money, you're better than people who actually have to work for theirs." I remember that sentence specifically because it was the first time I understood that Richard didn't see estate law as real work. He saw it as adjacent to wealth, close enough to touch it, never entitled to any of it. That belief would matter enormously later, though I didn't know it yet. Our divorce was finalized on March 14, 2022. It was by Mecklenburg County standards unremarkable. We split custody of Tyler roughly 60/40ths in my favor given my schedule flexibility as a partner. Richard kept his truck and his tools. I kept the house we'd bought in 2013 on Sardis Road, and neither of us contested much of anything because, frankly, there wasn't much to contest. Richard had gone through most of his severance, was working a mid-level sales job at a flooring distributor making around $71,000 a year, and had very little in retirement savings. I remember our mediator, a woman named Carol Jensen, saying to me privately after the final session, "He's going to need to find someone with money, Diane. Men like that usually do." I didn't think much of it at the time. I should have. Richard met Vanessa Pruitt in April 2023 through a work conference for building materials suppliers in Myrtle Beach. Vanessa worked in the marketing department for a competing distributor. She was 39, twice divorced herself, sharp-featured and quick-tongued in a way that I later realized Richard found intoxicating precisely because it reminded him of arguments he used to win. They married on June 3, 2023, in a ceremony at a vineyard outside Asheville that Tyler described to me afterward as kind of a lot. Honestly, Mom. Which from a 12-year-old boy is a significant piece of testimony. Here's the detail that matters most, the one small early warning sign that I want you to hold on to. At Tyler's 13th birthday party in June 2024, Vanessa mentioned almost in passing that her great-aunt Margaret, her mother's older sister, a woman in her early 80s who'd never married and never had children, owned a few dry cleaners and some property outside of Concord, North Carolina, about 25 minutes northeast of Charlotte. Vanessa said it lightly, the way you'd mention a nice used car, not a fortune. But I noticed the specific pride in how she said a few dry cleaners like she'd rehearsed underselling it. I didn't think anything more about it. I had no reason to. There are a lot of elderly women in the Charlotte metro area who own small businesses and rental property. It never crossed my mind that Margaret Ellis's name would appear on a case file crossing my desk 8 months later, or that the trust I would be retained to help administer belonged to the same woman. Vanessa Calloway had just called my great-aunt Margaret at my son's birthday party over a sheet cake I'd ordered from Publix. That's where it started. Now let me walk you through how it fell apart. The first incident I logged, mentally, not on paper. Because at that point, it was still just a divorced woman noticing something petty. Happened on August 9th, 2024. Richard picked Tyler up for his weekend and mentioned in front of our son that Vanessa had just put a $6,200 deposit down on a Sea Ray boat because her aunt's going to make sure we're set for life anyway. So why not enjoy it now? Tyler, who was 13 at the time and increasingly aware of the tension between his parents' two households, told me about it that Sunday night while doing homework at my kitchen table. Dad said Vanessa's aunt is basically rich, he said, not looking up from his math worksheet. He said we might get a boathouse next. I asked Tyler how Vanessa's aunt was doing, and he shrugged. I don't know. Vanessa doesn't visit her that much, I don't think. Dad says she's old and kind of confused sometimes. I filed that sentence away, confused sometimes. In my field, that phrase means something specific. It means capacity questions. It means the difference between a valid will and avoidable one. I told myself I was reading too much into a 13-year-old's second-hand account of an adult conversation he probably only half understood, and I let it go. The second incident came on October 11th, 2024. The basketball game, the one I opened this story with. Richard's exact words again were, "Some men just know how to pick a winner." Vanessa's about to come into some real money, and I'm about to retire at 52. A woman sitting next to me, a mother I recognized from Tyler's team, leaned over and asked, half-joking, inheritance? And Richard, overhearing, answered for Vanessa before she could answer for herself. Old family money. Aunt's got property all over Concord, and no other kids to leave it to. We're talking millions, easy. Vanessa smiled in a way I can only describe as practiced, the smile of someone who'd corrected Richard for saying this exact thing before and had given up correcting him. I want to pause on this moment because it's the one where dramatic irony really starts working in this story, and I think you'll feel it too. I sat 2 rows behind my ex-husband at my son's basketball game, listening to him brag about an inheritance I had already been retained 3 weeks earlier on September 20th, 2024, to help protect. I didn't know it was the same inheritance yet. Not consciously. But something in my stomach went cold anyway, the specific professional instinct you develop after 19 years of hearing families talk about money they don't understand yet. The third incident happened on December 22nd, 2024, at a holiday pickup exchange in the parking lot of a Harris Teeter on Providence Road. Richard was in an unusually good mood, the kind he only got in when he thought he was winning at something. He told me unprompted, standing by his truck while Tyler loaded his overnight bag into the back seat. You know, Vanessa's aunt had some kind of health scare a few weeks back. Mini stroke, I think. Vanessa says the doctor mentioned her memory's not what it used to be. He said this the way other people report the weather. Then he added, anyway, family's already talking about what happens next, if you know what I mean, and winked at me. Actually winked. My ex-husband winked at me in a grocery store parking lot while describing an elderly woman's declining cognitive health as a financial opportunity. I said, that's a shame. I hope she's doing okay, and got in my car, and sat in the Harris Teeter parking lot for 4 full minutes before starting the engine. Because for the first time, a specific and uncomfortable thought had crystallized. Mini stroke. Memory issues. Family already talking about what happens next. I had heard versions of that sentence before, professionally, and it was never good. Here's where I need you to stay with me, because this next part is the pivot point of the whole story. And I promised at the start I'd give you a moment to sit in before it all breaks open. If you're still with me, drop a like on this video right now and comment the word watching along with your city, because the next incident is the one where I found out exactly whose money Richard had been bragging about for 3 months. And I want to know how many of you saw it coming before I did. The fourth incident was the one that connected everything. On January 14th, 2025, I was in my office at Presley and Odom, reviewing case intake for a new trust administration matter that had been referred to me by a colleague in our Concord satellite office, Marcus Whitley, who specialized in small business succession and elder client estate planning. The client was an 81-year-old woman named Margaret Ellis, owner of 3 dry cleaning locations operating under the name Ellis Cleaners since 1971, plus a rental duplex on Union Street North in Concord. Plus a modest but well-funded investment portfolio her late brother had helped her build in the 1990s. Total estimated estate value, $3,850,000. Marcus was bringing me in as co-counsel because the matter had grown complicated. Margaret's health had declined following a minor cerebrovascular event in November 2024, and there were early concerns from a bank officer about unusual account activity and a recently drafted trust amendment that redirected the bulk of the estate away from Margaret's long-standing beneficiaries. I read the intake file at 9:47 a.m. on January 14, 2025. I got to the section listing interested parties, the people involved in Margaret's care and financial life, and there, in Marcus's careful handwriting, was a name, Vanessa Calloway, great-niece, primary contact since October 2024. I sat with that for a long moment. Vanessa Calloway, my ex-husband's wife. The woman whose aunt owned a few dry cleaners. The inheritance Richard had been bragging about at basketball games and grocery store parking lots for 3 months was sitting right now in a file on my desk, and I was about to become one of the 2 attorneys responsible for protecting it, or for determining whether it had already been stolen. I called Marcus into my office and asked him, as neutrally as I could manage, "Does the file say anything about Vanessa's husband?" "A man named Richard Calloway?" Marcus flipped through his notes and said, "Yeah, actually, he's been at a couple of the visits according to the bank officer's report." "Why, you know him?" I told Marcus the truth because in my profession, conflicts of interest are not optional disclosures, they're the whole job. "He's my ex-husband," I said. "We've been divorced 3 years. I need you to understand that before we go any further, because if there's any reason I can't stay objective on this file, I need to recuse myself right now." Marcus, to his credit, didn't panic. He asked me the only question that mattered. "Do you think you can be fair to Margaret Ellis specifically, not to Richard, not to Vanessa, to Margaret?" And I told him yes, because it was true. My job was never about Richard or Vanessa. It was about an 81-year-old woman who built 3 dry cleaning businesses from nothing starting in 1971, whose file now included a phrase that appeared 4 separate times in the bank officer's notes. Client appeared confused about the nature of the documents presented for signature. That phrase is the one that mattered. That phrase is the one I built a case around. Over the following 6 weeks, I did what I do for a living, except this time the stakes were personal in a way they'd never been before. I pulled the full trust file. Margaret Ellis had established a revocable living trust in 2016, naming her church's building fund, a local scholarship program for Concord High School graduates, and 2 second cousins as beneficiaries of roughly equal shares. Nobody named Vanessa anywhere in the original 2016 document. Then, on November 30th, 2024, 19 days after her mini-stroke and 11 days after being discharged from Atrium Health Cabarrus with documented short-term memory deficits, Margaret signed an amendment prepared by a solo practitioner attorney in Kannapolis named Gary Poteet, an attorney with no elder law background, and as I later confirmed, no prior professional relationship with Margaret. The amendment redirected 90% of the trust's assets to Vanessa Calloway, individually cutting the church fund, the scholarship program, and both second cousins down to a token $5,000 each. I want to give you the exact numbers, because I think they matter. The original 2016 trust distributed the estate in 4 roughly equal shares of approximately $875,000 each. The November 2024 amendment redirected $3,465,000 of the $3,850,000 estate to Vanessa Calloway alone, leaving $15,000 total to be split among the 3 original beneficiaries. 90% to a woman who, according to the bank officer's notes, had visited her great-aunt exactly 6 times in the 14 months preceding the amendment, and 3 of those 6 visits occurred in the 8 days immediately surrounding the signing. Richard's voice came back to me, unbidden, standing in that Harris Teeter parking lot. Family's already talking about what happens next, if you know what I mean. I called Marcus that evening at 8:15 p.m. and told him I needed to see the full medical file, the bank's suspicious activity report, and Gary Poteet's engagement letter, because I believed, professionally not personally, that we were looking at financial exploitation of a vulnerable adult under North Carolina General Statute 108A101. And possibly undue influence sufficient to void the November amendment entirely. Marcus asked me one more time if I was sure I could handle this given the family connection. I told him the truth. This isn't about my ex-husband. This is about a woman who ran 3 dry cleaning stores for over 50 years and deserves to have her actual wishes respected. whether or not her family likes the outcome. He agreed to keep me on the file, with a formal disclosure letter placed in Margaret's records noting my prior relationship to one of the interested parties, reviewed and approved by our firm's ethics committee on February 3, 2025. That was the discovery. Not a dramatic overheard phone call, not a document I stumbled onto by accident, a case file that landed on my desk through the ordinary mechanics of my job, and a series of numbers that told a story Richard and Vanessa never imagined I'd be positioned to read. I now knew, with more precision than either of them, exactly how much money was at stake, exactly how it had been redirected, and exactly how thin the legal ground was that it stood on. What I didn't know yet was how deliberate it had been. That came next. I spent the next 4 months building a case, and I want to walk you through exactly how, because the quiet, procedural part of this story is the part that actually mattered, not the confrontation everyone wants to skip ahead to, but the paperwork that made the confrontation possible. The first thing I did on February 5, 2025, was request Margaret Ellis's complete medical records from Atrium Health Cabarrus, going back 18 months, through a formal HIPAA-compliant authorization that Marcus obtained through Margaret's treating physician, Dr. Elaine Cho, who had been managing Margaret's care since 2019. Dr. Cho's notes from Margaret's November 11, 2024 discharge were unambiguous. Patient presents with short-term memory deficits consistent with post-CVA cognitive impairment. Recommend follow-up neuropsychological evaluation within 60 days. Patient should not be making significant financial or legal decisions without additional support pending further evaluation. That single sentence, should not be making significant financial or legal decisions, was dated November 11, 2024. The trust amendment was signed November 30, 2024. 19 days later, in direct contradiction of her own treating physician's written recommendation. The second thing I did was request the full file from First Carolina Trust Bank, where Margaret's accounts were held through their Elder Abuse Compliance Department. A bank officer named Renata Suarez had flagged 3 unusual transactions between October 2024 and January 2025, a $22,000 withdrawal on November 2, 2024, described in the memo line as gift, a $340,000 transfer into a joint account newly opened with Vanessa Calloway on December 18, 2024, and an attempted $500,000 wire transfer on January 9, 2025, which Renata had personally frozen pending review because Margaret, when called to verify the transaction, could not accurately state the amount or the recipient of the transfer she had reportedly authorized. I remember reading that line at 6:20 a.m. On February 11, 2025, before Tyler was even awake for school, and feeling something settle into place that had nothing to do with anger and everything to do with certainty. This wasn't ambiguous. This was documented, time-stamped, bank-verified financial exploitation of a woman who, 4 months earlier, had been told in writing by her own doctor not to make exactly this kind of decision. The third thing I did, and this is the part I want to be careful describing, because it's the part where I had to separate my job from my history, was pull Gary Poteet's full engagement file for the November 2024 amendment through a formal records request, since he was now effectively a witness in a potential undue influence proceeding. Poteet's intake notes showed he had met with Margaret exactly once, for 40 minutes on November 28, 2024, 2 days before the signing. Present at that meeting, according to Poteet's own notes, Vanessa Calloway. Also present for the final 15 minutes, according to a supplemental note Poteet added after the fact, V's husband, R. Calloway, arrived to drive client and V home. Briefly discussed timeline for completing paperwork. Richard was in the room. Not the primary actor. I never believed Richard drafted this scheme. He didn't have the patience or the paperwork instincts for it, but present, aware, and by his own bragging at a basketball game 3 months prior, fully informed that the family was already talking about what happens next. Whatever Richard told himself about his own involvement, the paper trail placed him in that room on November 28, 2024, 48 hours before an elderly woman with documented memory impairment signed away $3.465 million to his wife. I filed a formal petition with Marcus on March 17, 2025, in Cabarrus County Superior Court, seeking 3 things: an emergency freeze on the disputed accounts pending review, appointment of a guardian ad litem to represent Margaret's interests independently, and a formal challenge to the validity of the November 30th, 2024 Trust Amendment on grounds of lack of testamentary capacity and undue influence. I made a deliberate decision, one I still stand behind, not to name myself publicly on any filing that Richard or Vanessa would see before the hearing. Marcus served as lead counsel of record. I worked the file entirely behind the scenes, reviewing depositions, drafting the capacity argument, coordinating with Dr. Cho for an expert affidavit, while Vanessa and Richard had absolutely no idea that the attorney quietly dismantling their claim to $3.465 million had once been married to one of them, had raised his son, had sat 2 rows behind him at a basketball game listening to him call this exact money real money, and himself about to retire. If you've made it this far, I want you to comment one word for me, just ready, because the countermove I'm about to describe is the part of this story where everything I'd built over 19 years finally got used for something that mattered more than a fee. And if you haven't yet, hit subscribe now, because the confrontation scene is coming, and I promise you Richard's face when he finally understands who I am to this case is worth staying for. On April 2nd, 2025, Judge Renita Alford granted our emergency motion. The joint account containing the $340,000 transfer was frozen. The attempted $500,000 wire that Renata Suarez had flagged was formally voided. A guardian ad litem, a retired social worker named Phyllis Odom, no relation to my firm, was appointed to represent Margaret's interests independently of every family member involved, including Vanessa. Phyllis met with Margaret 3 times over the following month and, in her report filed May 9, 2025, concluded plainly, Ms. Ellis does not appear to understand the current disposition of her estate, cannot articulate why her longtime beneficiaries were removed, and expresses continued affection for her church and her cousins, whom she describes wanting to take care of, same as always. That sentence, same as always, undid the entire amendment in the eyes of the court, because it directly contradicted the premise that Margaret had knowingly and intentionally changed her wishes. It confirmed what Dr. Cho's note had implied and what the bank's frozen wire transfer had suggested. Margaret Ellis had not decided to give her great-niece $3.465 million. Margaret Ellis had signed a document she didn't fully understand 19 days after a stroke, 48 hours after a 40-minute meeting with a lawyer she'd met once, with her great-niece's husband in the room to drive her home afterward. The hearing was scheduled for June 24, 2025. I want to describe what I did in the weeks leading up to it, because this is the part I'm proudest of professionally. I did not call Richard. I did not warn Vanessa. I did not at any point use my relationship with Tyler or my history with Richard to gain any advantage or leak any information, because doing so would have compromised the case and, more importantly, would have made me exactly the kind of person I was building a case against. I stayed in my lane. I drafted a 15-page brief laying out the timeline. The stroke on November 11th, the doctor's written restriction the same day, the amendment on November 30th, the frozen $500,000 wire on January 9th, the Guardian ad litem's report on May 9th. I built it the way I'd build any capacity and undue influence case, dispassionately, on paper, on dates, on dollar figures that couldn't be argued with. On June 20th, 2025, 4 days before the hearing, Marcus finally filed the formal notice of appearance that would, for the first time, put my name on the public record as co-counsel for the Guardian ad litem's position. I knew Vanessa's attorney, a general practice lawyer named Todd Ferris out of Concord, would see that filing before the hearing. I knew there was a real chance Richard would find out who was sitting at that table before he walked into the courtroom. He didn't. Todd Ferris apparently never mentioned my name to his clients, or Richard and Vanessa never asked, or they assumed D. Whitfield-esque was simply unfamiliar. Whatever the reason, on the morning of June 24, 2025, Richard Calloway walked into courtroom 4B of the Cabarrus County Judicial Center at 9:52 a.m. Wearing a gray suit I recognized from our marriage, sat down next to Vanessa at the respondent's table, and did not look up at the co-counsel table until Judge Alford called the case. That's when he saw me. I watched it happen in real time. Richard's expression went through 3 distinct stages in about 4 seconds: recognition, confusion, and then a kind of dawning horror that I will admit, professionally, I had not fully prepared myself to feel satisfaction watching. Vanessa turned to follow his gaze, and her face did something similar, though hers settled faster into something more calculating. Diane? Richard said, loud enough that Judge Alford glanced up. "What is, Mr. Calloway? Please address the court, not counsel," Judge Alford said, not unkindly, just procedurally. Todd Ferris leaned over to Richard and whispered something. I watched Richard's jaw tighten. Vanessa grabbed his forearm, hard enough that I saw her knuckles whiten, and whispered something back. Judge Alford opened the hearing formally at 10:03 a.m., establishing the matter as in re the Margaret Ellis Revocable Trust, petition to void the November 30th, 2024 amendment on grounds of lack of testamentary capacity and undue influence. Marcus presented first, walking the court through the timeline I'd built, the November 11th stroke. Dr. Cho's written restriction the same day, the amendment signed 19 days later, the frozen wire transfer, the Guardian ad litem's findings. I sat beside him, occasionally passing him exhibit tabs, saying nothing, because my role that morning was support counsel, not lead, but I could feel Richard's eyes on me across the courtroom the entire time. Todd Ferris's cross-examination of Dr. Cho, called as an expert witness, was where things started to unravel for Vanessa's side. Dr. Cho testified plainly that her November 11th note restricting Margaret from significant financial decisions had been given verbally to Margaret and, per standard practice, to the family member present at discharge, and when Marcus asked who that family member was, Dr. Cho checked her records and answered, "The discharge log shows Vanessa Calloway signed as the accompanying family member on November 11th, 2024. Vanessa had been told, in writing on the day of discharge, not to let Margaret make major financial decisions. 19 days later, she brought her to a lawyer she'd found and paid for to sign away $3.465 million. Richard's attorney, separate counsel, he'd retained once it became clear he might be named in the undue influence claim, given his presence at the November 28 meeting, asked for a brief recess at 11:15 a.m. When we reconvened at 11:35, Richard was noticeably paler. During the recess, according to what Phyllis Odom told me afterward, Richard had learned for the first time from his own attorney that his presence in that room on November 28th exposed him to potential personal liability, not just Vanessa. The afternoon session was when Phyllis Odom testified directly. She described her 3 visits with Margaret in careful, unemotional detail, a professional describing a vulnerable person's reality without embellishment, which somehow made it more devastating than any theatrical account could have been. She quoted Margaret directly, reading from her notes. She told me on May 2nd, quote, "I don't understand why my cousins aren't coming around anymore. Did I do something wrong? I always wanted to take care of them, same as always." End quote. I watched Vanessa's composure crack for the first time. She put her hand over her mouth. Richard reached for her, and she pulled away from him. A small motion, but I saw it, and I think Judge Alford saw it too. Judge Alford called a 15-minute recess at 2:40 p.m., before closing arguments. Richard approached me in the hallway outside courtroom 4B, which he was not supposed to do, and which Todd Ferris immediately tried to stop, but Richard shook him off. "You did this," Richard said. His voice was low, controlled in a way I hadn't heard from him in years, which somehow made it worse. "You've been on this the whole time and you never said a word." "I didn't know it was connected to you until January," I said, keeping my voice level. The same voice I use in every deposition I've ever conducted. "And once I did, I had a legal and ethical obligation to disclose the conflict, which I did in writing to the firm's ethics committee on February 3rd. This was never about you, Richard. It was never even about Vanessa. It was about an 81-year-old woman whose doctor told her family in writing not to let her sign anything major. And your wife took her to a lawyer 19 days later anyway. She's my wife. That money was supposed to be..." He stopped himself. "Supposed to be what?" I asked. "You said it yourself at Tyler's basketball game, in front of half the parents on that team. Some men just know how to pick a winner. You called it real money before either of you had any legal right to it. That's the part you don't seem to understand, Richard. It was never yours to brag about." "It still isn't." He didn't have an answer for that. I want to note, because I promised composure throughout this, that I said all of this quietly, without raising my voice, without a single word I'd later regret. Richard was the one whose hands were shaking. Vanessa came out of the courtroom then, having apparently asked Todd Ferris where Richard had gone, and found us in the hallway. "You," she said to me, and I could hear the effort it took her to keep her own voice controlled. You've been sitting on this since January and you let Richard keep talking about it at parties like some kind of... I had an ethical obligation to disclose my conflict to the court and to my firm, which I did, I said again, evenly. I did not have any obligation to warn either of you that you were exploiting a vulnerable woman whose own doctor told you in writing not to. That's not a conflict of interest. That's the entire reason this hearing exists. Judge Alford's clerk called us back in at 2:58 p.m. Closing arguments took 40 minutes. At 4:12 p.m., Judge Alford ruled from the bench. The November 30th, 2024 trust amendment was voided in full, on the combined grounds of lack of testamentary capacity, citing Dr. Cho's contemporaneous medical restriction, and undue influence, citing the guardian ad litem's report and the pattern of isolation documented in the visitation records. The original 2016 trust terms were reinstated in full: the Church Building Fund, the Concord High School Scholarship Program, and Margaret's two second cousins would receive their original shares, totaling approximately $875,000 each. Vanessa Calloway would receive nothing beyond what she'd been entitled to as a named beneficiary under the 2016 document, which was to say nothing at all since she hadn't been named in it. Judge Alford also referred the matter to the Cabarrus County District Attorney's Office for review of potential financial exploitation of a vulnerable adult under North Carolina General Statute 14-112. 2. Specifically naming Vanessa Calloway and Gary Poteet as parties whose conduct warranted investigation. Richard's name was not referred criminally. His presence at the November 28th meeting was documented but insufficient on its own to establish criminal intent. But Judge Alford noted for the record that his knowledge of the scheme, as evidenced by witness testimony regarding public statements he'd made about the inheritance, would be relevant to any civil claims Margaret's guardian ad litem chose to pursue for restitution. Some men just know how to pick a winner. I thought about that phrase one more time as I watched Richard sit motionless at the respondent's table, staring at nothing, while Vanessa gathered her things beside him without looking at him at all. The consequences unfolded over the following 4 months, and I tracked them the way I track every closed case, carefully, without gloating, because gloating isn't professional, and honestly, by that point, I didn't feel much satisfaction in it. Mostly I felt tired and relieved and glad that an 81-year-old woman got to keep believing she'd taken care of her family, same as always. On July 30th, 2025, the Cabarrus County District Attorney's Office formally charged Vanessa Calloway with financial exploitation of a disabled or elder adult, a Class F felony under North Carolina law given the dollar amount involved. She retained private counsel and on October 14, 2025, entered an Alford plea, avoiding trial in exchange for restitution and 5 years of supervised probation. Gary Poteet, the attorney who drafted the amendment after a single 40-minute meeting, was referred to the North Carolina State Bar for disciplinary review. His license was suspended for 18 months and a decision issued February 2026, with the disciplinary panel specifically citing his failure to conduct any capacity assessment, despite documented red flags in Margaret's medical history. Richard was never criminally charged, but the civil restitution claim Phyllis Odom filed on Margaret's behalf, on August 12, 2025, named both Vanessa and Richard jointly, on the theory that marital assets, including the $6,200 boat deposit from August 2024 and a portion of a joint checking account, had been funded in anticipation of, and partly using early transfers from, the disputed inheritance. Richard settled that claim in November 2025 for $34,000, money he had to borrow against his 401k to pay at a considerable early withdrawal penalty. He and Vanessa separated in January 2026. Though as of this recording, they have not finalized a divorce. Tyler, now 15, split time between us throughout all of this, and I made a deliberate choice never to discuss the case with him in detail. He learned most of what happened from Richard directly, in fragments, the way teenagers usually learn about their parents' failures. He asked me once in March 2026, "Did you know it was Dad's wife's aunt this whole time?" And I told him the truth. I found out in January. I had an obligation to keep working the case fairly once I did, and I never let my history with his father change how I treated Margaret Ellis or anyone else involved. He seemed satisfied with that answer, in the specific way 15-year-olds are satisfied with an answer that lets them stop thinking about something uncomfortable. Margaret Ellis, as of this recording, is 82 years old, living independently with part-time home care, and according to Phyllis Odom's final report, filed December 2025, expresses relief and continued affection for her extended family, particularly her cousins Doreen and Faye, whom she now sees monthly. I have not spoken to Margaret directly since the case closed. My ethical obligations ended there, and I preferred to keep it that way, but Marcus tells me she still runs the books for Ellis Cleaners 3 mornings a week. Same as she has since 1971. I did not reconcile with Richard, and I don't expect I ever will in any meaningful sense. But we still co-parent Tyler, and at his 16th birthday dinner in June 2026, Richard shook my hand in the parking lot afterward and said quietly, without his usual performance, "You were always better at this than people gave you credit for." I never should have said what I said. I told him I appreciated that, and I meant it, and I also told him that I hoped he and Vanessa found some peace, separately or otherwise, because staying angry at people forever isn't really my style. The door isn't closed between us as Tyler's parents. It's not open to anything more than that either. I think that's the honest way this kind of story actually ends. Here's what I want you to take from all of this, if nothing else. Being underestimated is not the same thing as being powerless. For 3 years, Richard treated my career like a punchline. Paperwork for rich people. Cute. Safe. That paperwork turned out to be the only thing standing between a vulnerable woman and losing everything she'd built across 54 years of running a small business. You don't always know when someone dismisses what you do, that you're the one who's going to end up holding the file that decides everything. Stay good at your work. Stay quiet about your power. Let people underestimate you right up until the moment it matters. If this story meant something to you, I'd love to hear it. Comment below and tell me what you would have done in my position. Share this with someone who needs to hear that being underestimated isn't the end of the story. And if you haven't already, subscribe to the channel, because there are a lot more of these stories where quiet, careful people turned out to be exactly the ones who couldn't be fooled.